Welcome to Law in Layers, where we break down the law one layer at a time. Today, we'll be breaking down the basics of theft. Most people think theft simply means stealing physical objects, but legally, it's much broader than that. Theft is defined under Section 1(1) of the Theft Act 1968. It states that a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. In simpler terms, theft requires three key elements: dishonesty, the appropriation of property belonging to someone else, and the intention to permanently deprive them of it. We begin with the Actus Reus, the physical element of the offense. This is made up of three parts: appropriation, property, and belonging to another. First, we will discuss appropriation. Section 3(1) of the Theft Act 1968 defines appropriation as any assumption of the rights of an owner. In other words, it happens when someone treats property as if it were their own by taking, using, keeping, or dealing with it. For example, taking someone's phone without permission would clearly be an appropriation. Importantly, this can also occur where someone initially obtains property innocently but later decides to keep or use it as their own. This was shown in R.V. Morris, where the defendant switched price labels in a supermarket to pay less. The Supreme Court held that appropriation involves an assumption of the owner's rights, even if only one of those rights is exercised. The conviction was upheld. Even more surprisingly, appropriation can occur even where property is given as a genuine gift. In R.V. Hinks, the defendant, a carer, persuaded a vulnerable man to transfer around £60,000 and a television to her, which she claimed were valid gifts. The House of Lords held that even a valid gift can amount to appropriation if it is obtained dishonestly. Next is property. Section 4(1) of the Theft Act 1968 states that property includes money, real or personal property, things in action, and other intangible property. However, there are exceptions. For example, wild mushrooms cannot be stolen unless they are taken for commercial purposes under Section 4(3). A key case here is Oxford v. Moss, where a student obtained advance knowledge of an exam paper, used it, and then returned it. The court held that information alone is not property under the Act, only the physical paper itself can be stolen, not the knowledge on it. Finally, we have belonging to another. Section 5(1) explains that property belongs to anyone who has possession, control, or a proprietary interest in it. So yes, surprisingly, you can even be guilty of stealing your own property. In R.V. Turner, No. 2, the defendant took his own car from a garage without paying for repairs. Even though it was his car, it was in the possession of the garage, meaning it belonged to another for the purposes of theft. Section 5 also expands this further. Under Section 5(3), where someone receives property under an obligation to deal with it in a specific way, it can still belong to another. For example, if money is given for electricity bills but spent on something else, this may amount to theft. This was illustrated in R.V. Wayne, where the defendant collected money for charity but later diverted it for personal use. The court held that he was under an obligation to deal with the funds in a specific way, meaning the money still belonged to another. Finally, under Section 5(4), if someone receives property by mistake and is obliged to return it, it is still regarded as belonging to the original owner. This was confirmed in Attorney General's reference, No. 1 of 1983, where the court held that once the recipient became aware of the mistake, they were under a duty to restore the money. Failure to do so could amount to theft if accompanied by dishonesty and an intention to permanently deprive. After establishing that the defendant has the Actus Reus for theft, the prosecution must then prove the mens rea. This is the mental element of the offense, and therefore often the most difficult to establish. For theft, there are two key elements: dishonesty and intention to permanently deprive. We begin with dishonesty. Under Section 2(1) of the Theft Act 1968, a person's appropriation is not dishonest if they believe that 1. They have a legal right to deprive the other of the property. 2. The owner would have consented if they knew the circumstances, or 3. The owner cannot be found by taking reasonable steps. If any of these apply, dishonesty is automatically negated. However, if none of these defenses apply, The courts use the modern test for dishonesty established in Ivey v. Genting Casinos. This test asks two questions. First, what was the defendant's actual knowledge or belief as to the facts? Second, would their conduct be considered dishonest by the standards of ordinary decent people? This replaced the older test from R v. Gauche, which required not only that the conduct was objectively dishonest, but also that the defendant realized it was dishonest by those standards. That subjective second limb is no longer required. The second element is intention to permanently deprive. Under Section 6(1) of the Theft Act 1968, a person intends to permanently deprive if they treat the property as their own to dispose of, regardless of the owner's rights. In some cases, even borrowing or lending can amount to this if it is for so long, or in such circumstances, that it is effectively equivalent to outright taking. This was considered in DPP v. Lavender, where the court confirmed that treating property as one's own, disregarding the owner's rights, can satisfy this element. Section 6(2) goes further. It states that if a person parts with property under a condition they may not be able to fulfill, especially for their own benefit and without authority, this can also amount to treating the property as their own. Another key case is R v. Lloyd, where the court held that borrowing will only amount to an intention to permanently deprive if the property is returned in such a diminished state that it has effectively lost its value, or all its goodness and virtue. If both the Actus Reus and mens rea are satisfied, the defendant will be guilty of theft. Theft is an either-way offense, meaning it can be tried in either the magistrate's court or the Crown Court depending on severity. The maximum sentence for basic theft is 7 years imprisonment. Thank you for watching Law in Layers. If you found this helpful, make sure to like, comment, share, and subscribe. I'll see you next time, as we continue to understand the law one layer at a time.